Go ahead and be seated, everybody. Before we start, intentions of the parties. Are more than one person going to present on behalf of the appellants?
No, Your Honor.
Okay. If I can ask respondents, are more than one person going to present on behalf of the respondents? Okay. That societal order reigns. 30 minutes per side. How much time would you like to reserve for rebuttal?
I would like to save 6 minutes for rebuttal, Your Honor.
Okay. Now, if I can perform the functions of a 13-year-old and make this clock work right, we're in business. And we are in business. Go ahead and proceed.
Thank you. Jean-Claude Andre on behalf of Pharmacia. There's a lot at issue in this case, and while I'll endeavor to discuss some additional issues, I plan to focus this morning on the WPLA issues. With the WPLA, the legislature carefully balanced the interests of, quote, the consuming public, the product seller, the manufacturer, and the product liability insurer by including a 12-year statute of repose and limiting damages to those as recognized by the courts of the state. As the Supreme Court explained in Graybar, the WPLA creates an exclusive and preemptive remedy, and it would accomplish little if plaintiffs were able to pick and choose which provisions they would have to abide by. The trial court here permitted plaintiffs to do exactly what Graybar forbids in two critical ways: by excising the statute of repose from the WPLA and importing Missouri punitive damages in this case. I'd like to start with repose, if I may.
Okay, let me going to have a question or two about that.
Sure.
And as a starting point, so everybody understands, everybody should assume three things are true: that everybody on the panel has read all the briefing, that the panel discussed this case during the course of a 3.5-hour conference yesterday, and that because of the size of the record, none of the judges should be anticipate that we've seen everything in the thousands of pages. So legal arguments, yes. What's in the briefing, yes. Anything in the record that's significant, make sure you tell us where it is, okay? My question for you then, statutes of repose can be of two types. One I will call a general statute of repose. The second I will call a specific statute of repose. No other judge that I'm aware of shares my view on this, but I think I'm going to explain what I mean. So Washington has a builders and contractors statute of repose, RCW 416, 300 through 325. It applies to any and all claims against a specified group of individuals or tradesmen, okay? It was adopted by the legislature and then superimposed over pre-existing remedies. WPLA came about differently. It would be a specific, in my view, statute of repose, applying to a specific cause of action or sets of cause of action created in the same bill or sets of bills. Why would we analyze those two things in the same way?
Well, I don't think you have to in this case. I think that the crux of the distinction you articulated, Judge Dwyer, I think is critical. If the statute of repose, or let's call it actually the repose provision because it's part of a larger statute,
right,
at least with respect to WPLA.
Right.
If the repose provision is a condition precedent to the cause of action, adheres in it, is part of it, an element of it, then it is not severable in our view for a number of reasons that I'll get to in a second. If it's collateral to the cause of action, such as the builders and contractors example you gave, or a general statute of limitations, some background principle that may operate to a class of various claims, then it would be severable. Again, this case is, I think, probably the easier one than the builders and contractors example because .060 is part of the WPLA, and we've all looked at it. It's not that big of a statute. And it creates an element that plaintiffs must satisfy in order to have a viable cause of action. And so the reasons why we think it's not severable are, at least two. One, the Supreme Court in Rice twice said, not just once, but twice said, that when you apply the substantive law of a state, you also apply the substantive statute of repose. Now, again, I realize that your question to me may make Rice distinguishable in some certain contexts, but again, not here. The second reason is Restatement 6 sub 1. There, where there's a directive to apply local law in the statute, irrespective of any other principles in the restatement, you apply that local law. Here, we believe we have a very clear directive from the legislature that the local statute of repose must apply. We have the Matter of Able case from Division 3, I believe, which looked at child support schedules and applied 6 sub 1. And in that case, even though the claimants had moved from Montana to Washington, the court said, well, that child support schedule says that Washington schedule shall apply, and therefore 6 sub 1 requires its application regardless of any other choice of law principles. Here, our local directive is even stronger, because in the WPLA, the statute of repose says that it shall apply to any cause of action under this subchapter, meaning that if plaintiffs had decided to sue Pharmacia in Missouri and the WPLA were to apply even there or in federal court, the statute of repose would have to go with it. And so we think that's the cleanest way to establish that statute of repose has to apply in this case. And then the question becomes, I guess, what does this court or what does the trial court do with it? We think we're entitled to.
What did you ask the trial court to do with it? Because you're anticipating my next question.
Well, so we
Either what, if we agree with you, what's the remedy you get here, or what remedy did you seek in the trial court?
We sought alternative remedies, and I guess it'd be the same alternative remedies that I'd be asking at your court to order. We asked for summary judgment on it because we thought that the evidence was, irrefutable that the PCBs here were beyond their 12-year.
What was it on which you asked for summary judgment?
On the statute of repose. That the statute of repose.
On the applicability or the application?
Both. That it applied, and that based on the undisputed facts that we were entitled to summary judgment and then eventually, JMAL on it.
Were those undisputed facts reliant on the 12-year presumption or on other evidence that you submitted as to the actual useful life?
Based on the 12-year presumption and plaintiff's inability to establish that the product had a longer than 12-year useful safe life.
The 12-year presumption coupled with an absence of rebuttal evidence.
Correct. And then the alternative remedy would be that at minimum this should have been tendered to the jury, and the jury should have been able to look at whether the useful safe life was somehow longer than the 12 years, than the 12-year presumption. And so again, we think we're entitled to judgment on it, but I understand that's strong medicine. At minimum, though, the jury should have been given this question, and it wasn't in this case.
If there were a remand, it sounds like you conceded that this would be, because it's a part of the cause of action itself. There's an opinion that Justice Kennedy penned where he cited with approval a North Carolina court calling it an element.
Mm-hmm.
That would necessarily have to go, if the other elements of the offense, if the other elements of the claim would go to a jury, this would have to go to a jury too.
Unless we could get summary judgment on it on the basis of undisputed
I'm
facts.
assuming there would be some factual dispute.
Plaintiffs.
I don't know that. I'm just saying. So anything that would go to a jury never has to go to a jury if you get summary judgment on it. So, but then is it necessary to retry everything, or can there be a single issue trial for a jury to determine this, to resolve any factual issues, if there are factual issues, on the statute of repose question?
Gosh, to be honest, that's a good question that I hadn't thought about. I think
it's amazing that there's anything in all of this briefing, but I'm open to the possibility. Yeah.
No, I think it would probably have to be a retrial because the complexion of the case would be different. Again, assuming that this was tendered to the jury, we would put on evidence about how the useful safe life is 12 years or a little bit beyond that. I mean, there was some testimony in this case from Dr. Cayley, our company witness, who talked about, look, at most, the useful safe life of PCBs, even when contained, is 15 years. I guess plaintiffs may come back and say, well, but, we found PCB capacitors and MSD 40 years after Monsanto stopped making them. And so maybe that's, a dispute. But that evidence would come in, and I think that would affect.
But a jury would determine that.
Correct.
Right? I mean, it's set up to be a factual question by the language of the provision itself.
Right.
If the jury determined it one way, then it would not be a barter recovery, and the decisions have already been made by another jury. If the jury determined it in your favor, it would be a barter recovery, and nothing else would need be decided.
Thinking about this a little bit more here on the fly, admittedly, I think plaintiffs have a footnote in their brief where they say that they basically reserve the right to argue that this should go to a jury, and that they should be able to put on evidence that we intentionally misrepresented facts about the efficacy and safety of the product. And certainly, if we had a limited retrial on repose, and that evidence were to come in, and the jury were to reject that evidence, then I think you'd have inconsistent verdicts or something pretty close to that. And so that's a reason why, again, just speaking extemporaneously, why I think it would have to be a full remand for a full retrial.
In conjunction with that asserted reservation of rights, a phrase that always gets my attention in terms of evaluating the efficacy of such a reservation, was there an offer of proof? What would be proved? later on. The witnesses aren't here, but this is what we're going to show.
I don't mean, my apologies, I don't recall seeing an offer of proof on that. There very well may have been. I don't want to misspeak and overstate something. But certainly they had to have a footnote in their brief, referencing this exception to .060 and the presumptive 12-year useful safe life, and they've asked for a retrial on that if we don't get judgment. And so to answer your initial question again, if this does go back for a retrial, I think it needs to be a full retrial so that we don't have this potential of inconsistent jury findings.
Well, when you say inconsistent jury findings, I mean, the jury at this trial wasn't asked the specific question regarding safe life use, correct?
That's correct. But with respect to misrepresenting facts about the product, plaintiffs certainly tried to introduce some evidence in the original trial to say.
Right, but if there was a remand and there was a trial specifically to any disputed facts as to this question, then couldn't we consider the results of that and its application to what happened with the trial that had already occurred? Why would that be inconsistent?
Because I think, at least under plaintiff's characterization, they believe that they have already proven to the jury in the trial that already occurred that there were misrepresentations about the facts and the safety of this product. And if we do a remand for a limited retrial on repose, then those facts are going to be put before a different jury.
But without the actual findings by the jury on what they found, even if evidence was represented, we don't know because they're not asked to make the determination at the end to this question.
No, right. But I guess my point is that I don't know what this court would do if you had plaintiffs construing the first jury verdict as coming really close to resolving this question in .060B sub 2, and then you had a second jury rejecting .060B sub 2. I mean, again, this is something that we hadn't thought about, hadn't briefed, but it seems really complicated and messy to me, and it seems to militate in favor of full
I think
retrial.
that we compare the verdicts because that's what we know what juries do.
True.
And if there's no indication of an inconsistency from verdicts, in other words, if there weren't interrogatories to the first jury and there was to the second, there would be no inconsistency.
True.
But that's just me thinking extemporaneously.
No, understood. Given the clarity of our 6 sub 1 argument and the kind of anti-severability of the statute of repose, I don't think this court needs to get into 6 sub 2 and looking at the various factors, but if this court were to look at them, I think the strongest evidence, or it's two pieces of particularly strong evidence. One is when you look at the interests of the other state, in this case Missouri, with respect to 6 sub 2 sub C, Grosshardt, an opinion from the Missouri Court of Appeals just 2 years ago, refused to apply Missouri's lack of statute of repose to a Missouri defendant where there were Kansas claims. In other words, Missouri refused to export its lack of statute of repose to Kansas claims with a home state defendant. And for the same reason that Missouri refused to do that, I think this court should not import Missouri's statute of repose as a policy matter into the WPLA. Again, this is all related to 6 sub 2.
It appears there's no case that has ever divided a WPLA claim from its statute of repose.
That is absolutely correct, Your Honor.
And the significance of that is what?
Well, there's two significances, if I may. One, I think if you're referring to Martin and Zaneta, the 6 sub 1 argument just wasn't made in those cases, right? And there's longstanding law, I think, in every jurisdiction, but certainly in this jurisdiction, the kind of potential issues lurking behind judicial opinions aren't holdings and don't create precedent. And so I think, to the extent that Martin and Zaneta are relevant, they're relevant only on 6 sub 2. But what is telling is that in the application of 6 sub 2, in both of those cases, the substantive law and the statutes of repose stayed with the substantive law. And so if this court were to embrace plaintiff's position, this would in fact be the first opinion to sever off a statute of repose from the substantive claims. And so that would at minimum, make some waves, but also for the reasons I'm explaining, I think would be legally wrong. And the other factor that I was going to mention that's particularly compelling if you're going down the 6 sub 2 analysis is that the WPLA was modeled after the Model Uniform Product Liability Act. That also has a repose 12-year useful safe life provision. And so to the extent that one of the factors is to look at the overall policies of the body of law within which these claims rest, which is product liability law, the Model Act looks just like the WPLA. And so if you're not going to sever off from the Model Act, the statute of repose, you shouldn't do so here as well.
So your position would be that we should not undertake that same analysis that the other courts did in Martin and Zeneda, and we don't even get there?
Right, that you don't get there. I mean, you could in the alternative if you want to, or I guess if you disagree with my 6 sub 1 argument, then you'd have to. But yes, our position is that 6 sub 1, matter of able, the restatement, they're all clear, you don't get there, and so then it tees up the question of remedy that Judge Dwyer asked me about.
Would it be different if this were a kind of statute of repose that had just a clear time limitation? Because there are sort of different flavors of statutes of repose, and some look more like statutes of limitation.
I don't think so, because the critical, and it's funny you mentioned that, reading the scholarship, there's some scholarship talking about how, I guess when I was literally a baby decades ago, that courts used to confuse statute of limitations and statutes of repose, and that only, in the last couple of decades have they come to kind of crystallize the distinction. Right? A statute of limitations puts a limit on when a claim may be brought after the claim accrues, whereas a statute of repose, whether it has exceptions like the WPLA, potential exceptions, or whether it is just a flat-out, 8-year repose, 12-year repose, you can pick the number you want, that a statute of repose is a condition precedent to a cause of action being brought or extinguishes the claim regardless of when it accrues. So I don't think that the presence of the exceptions here in .060 sub B matter for purposes of your analysis, because it is clearly a statute of repose, not a statute of limitations. Seeing that my time is moving by quickly, I guess I wanted to quickly pivot to 2 of plaintiff's critical experts, industrial hygienist Kevin Coughlin and neuropsychologist Richard Perillo. To this, we made a strong showing in the trial court that both of these experts were applying novel methodologies not generally accepted in the scientific community. We weren't challenging their theory. We weren't challenging their conclusions. We weren't asserting laboratory error or nitpicking, a detail, such as in all the DNA cases the plaintiffs have relied on. To this day, because this is a burden-shifting regime, plaintiffs have still not come forward with any evidence as to how what Coughlin and what Perillo did was generally accepted in their relevant communities.
So Coughlin's conclusions were given effect by the testimony of a toxicologist.
I'm not sure I agree with that, Your Honor.
That's what the doctor testified to. He relied on Coughlin's data.
Oh, my apologies. So the toxicologist was Dr. DeGrandchamp. Dr. Dahlgren was the specific causation expert.
Okay, yeah. But what is the relevant scientific community?
Well, the relevant scientific
the community of the person who testifies as to what it means and what they would rely on, or the community of the people who would gather the data but not testify beyond to medical causation or other questions?
I think it could be both. I mean,
Can it be either? Because if it's either, it seems it comes in.
Well, I guess.
I mean, if it's not both, but it's either, is what I'm saying. It could come in, is what I'm saying.
I guess I'd have to disagree with that too, because I mean, our position here is, again, it's not one relating to the conclusions. We are making a Lake Chelan a more